Throughout the international law course, I have learned two important concepts. These concepts include conflict resolution and trade agreements. Conflict resolutions can be accomplished through a couple of different means. One is mediation. This is a voluntary, non-binding conflict resolution process where both parties gather together to discuss the issue with an impartial person to guide them through the process. There are no official court records kept, and the parties may seek legal litigation process if they're not satisfied with those results. The next process is an arbitration. Again, this is a binding resolution where an impartial person still hears the results, but there are court records kept through this. The third is through a litigation process where the arguments are heard in front of a judge. There are court records kept. Evidence is heard and the results are determined by the judge. All three of these must be determined by a jurisdiction. So where the court case may be heard is determined by subject matter or by territory. Both parties must agree on the venue before it can be moved forward. Within trade agreements, these often can be formal legal agreements that are required to be approved by the Senate before they can be put in place within a foreign nation. However, some of them, and many of them, are often informal agreements made by the President without the approval of the Senate, and they are done on a more frequent basis. Trade agreements allow for trade between nations across border lines. They give lower tariff rates on products and goods between these countries. They also offer lower restrictions placed on those goods being transported across these countries.